This is Bloomberg Law with June Grasso from Bloomberg Radio.
By a vote of 8-1, the Supreme Court upheld a federal gun law that bars people under domestic violence restraining orders from having firearms. The majority decision, written by Chief Justice John Roberts, tempers the court's expansion of constitutional gun rights, saying the Constitution's Second Amendment isn't so broad that it protects the gun rights of those found to be dangerous. And during oral arguments, it was clear that the defendant was one of those people. Here's the chief questioning his attorney, Assistant Federal Public Defender J. Matthew Wright.
You don't have any doubt that your client's a dangerous person, do you?
Your Honor, I would want to know what dangerous person means.
It means someone who's shooting, at people. That's a good start.
This case was the court's first application of its 2022 landmark ruling in the Bruin case, which established a constitutional right to carry a handgun in public and said gun laws can only survive if the government can show a history of similar restrictions. Joining me is an expert in the Second Amendment, Joseph Blocher, a professor at Duke Law School. Joseph, tell us about the decision.
So in some ways, this is a very comfortable win for the government. That's 8-1, supporting the constitutionality of a federal law that allows people to be disarmed if a judge finds that they present a credible threat to somebody else. So that's a win. The only dissent is Justice Thomas, who, of course, authored the Supreme Court's 2022 opinion in Bruin, which is the test that the court is applying in the case. So that's a little bit of an interesting wrinkle. In some other ways, though, I think it's about as narrow a win as the government could have gotten. There's a lot of emphasis here on just how extraordinary the facts are in this case. We have here a person who abused his intimate partner, who attacked her, who then agreed to an order which itself found that he presented a credible threat to her, and then went on to possess a gun in violation of that order, and it seems from the record probably engage in a bunch of other gun-related crimes. So in some respects, it's extraordinary that it took 100 pages of opinions from the court to decide that a person like that can constitutionally be denied access to firearms. But that's what we got. And again, the majority opinion here, joined by 8 justices, in that respect, not a close case. But then we get really a remarkable set of concurrences and then the one very prominent dissent from Justice Thomas.
5 justices writing separate concurring opinions. Does that expose divisions among the justices on gun rights issues?
Well, it's really interesting. I mean, as it reads to me, the concurrences from Justices Gorsuch, Kavanaugh, and Barrett, none of which join the others, so they're all writing separately, are really more like meditations on originalism than they are about guns specifically. I mean, just to oversimplify, in some ways it feels to me like Justice Gorsuch's concurrence is, here's why we should do originalism, and Justice Kavanaugh's opinion is, here's how to do originalism, and Justice Barrett's is sort of like what originalism is. And I think that Rahimi going forward, in addition to its importance for this particular law and for gun rights and regulation, I think is going to be, a go-to case for how the justices think about originalism. And that in itself is really fascinating. To me, the takeaway from the majority opinion, and in some ways the back and forth between the majority and Justice Thomas, is really about, at what level of generality can you take lessons from history? The majority really emphasizes the word principles. When we look at history, we're not looking just for specific examples. We're not looking for law trapped in amber, as the Chief Justice says in his majority opinion, but for principles, right? Something that makes the past usable. And that in itself is interesting. I don't want to call them essays. These are opinions from the justices, but in some ways almost read like academic essays about how originalism does or should work.
The Chief wrote, "Our tradition of firearm regulation allows the government to disarm individuals who present a credible threat to the physical safety of others." Is that the standard then for gun regulations going forward, a credible threat?
I certainly hope not. I mean, certainly those people should be disarmed. And if that's, the floor, I guess that makes sense. But if the requirement going forward is that a judge has to, in every individual case, determine that a person presents a credible threat to others in order to disarm them, then I think federal and state gun laws are just going to be in disarray. Because, for example, right now, like a person who commits a violent felony, can be disarmed under federal law, but that doesn't require that a judge go on and make a finding whether that person presents a credible threat, right? Or, laws restricting access to firearms by minors, for example, right? Like those don't require individualized findings of credible threats. So the easiness of this case, or what should be the easiness of this case, I hope doesn't become the standard going forward. I mean, there's a really important role, I think, for sort of group-based prohibition. If you commit certain kinds of violent crimes, being subject to disarmament, I think, is consistent with history, common sense, and hopefully the doctrine that the court announced.
Is this decision a step back from the court's constitutional expansion of gun rights?
Yeah, in a way, I think what we're seeing in Rahimi is a clarification, I guess, of the opinion in Bruin, which is the one that said, the only test for the constitutionality of gun laws is whether they are consistent with this nation's historical tradition of gun regulation, not whether they, for example, further important government interests by saving lives. Like, we can't do the means and scrutiny. We have to reason from history. And, in the opinion, the court doesn't really walk that back. I mean, they're still focused on text, history, and tradition, but they do give it some more nuance by saying what we look for in text, history, and tradition is principles, not just specific examples of regulations. The only opinion that I think really points to the sort of governmental motivations underlying this relatively recent law comes in Justice Sotomayor's concurrence, joined by Justice Kagan, where she points out, just the horrible, horrible reality of gun-linked intimate partner violence, particularly directed at women. But in most of the other opinions, that's not the focus. The focus is still on history. So it is a little bit maybe of trimming the sails of the Bruin decision, but it's not, in my reading at least, really walking it back quite as much as it might have.
We've seen with the Bruin, this confusion about how to apply this history and tradition test, and judges sweeping aside gun control laws that have been on the books for decades. Will this lead to fewer gun control laws being swept aside?
I think it's hard to tell. I mean, again, the court doesn't repudiate Bruin, so I think lower courts are still going to be citing the historical test. I would hope that they take the guidance here and apply it with more flexibility than the Fifth Circuit did in the opinion that the court overturns here. But, Justice Jackson raises this in her concurring opinion. I suspect we will continue to see, just challenges in the lower courts, diverging results on the constitutionality of the same kinds of laws. And this is really Justice Jackson's message, is that we, as the justices of the court, when we announce tests that the lower courts have to apply, should be paying attention to whether the tasks we give them are administrable, whether the doctrine is working. And in her view, it's not. That we're getting divergent results. We're actually seeing a lot of judicial discretion creep in, despite, the frequent claim in favor of originalism that it constrains judges. We're actually seeing a lot more confusion than we saw before Bruin, and it seems like, some more judicial discretion creeping in. So I don't think this is the end of that. I would say I also don't think that this is the last Second Amendment case we'll be seeing from this court. This case, as I read it, does not resolve questions about the constitutionality of, for example, prohibiting high-capacity magazines or prohibiting guns in sensitive places, polling places, and so on. Those are things that the court's going to have to confront, I think, in other cases going forward, and they certainly have a lot of options. There's a lot of cases percolating.
How do you read this in conjunction with last week's ruling that tossed out the ban on bump stocks?
I think that they're different, just because the questions presented are very different. The Cargill case last week on bump stocks was really about how an agency was interpreting statutory language. And here we're really dealing with a sort of much broader question of constitutional methodology. So I think the questions just present themselves very differently. If Congress, for example, disagrees with how the court ruled in Cargill, it can fix the issue by statute. Here we're dealing with a question of constitutional law. So I think in that respect, very, very different.
Justice Clarence Thomas was the one dissenter in this case. Is there a gun regulation that he will ever approve of?
It's tough to know. I mean, he closes his opinion by saying, and I think this is arguably a little bit misleading, he says this case is not about whether states can disarm people who threaten others. Well, of course, that's precisely what domestic violence restraining orders are for. That's what they do. What he means is that if Zaki Rahimi, who's the petitioner here, were convicted of the crimes he's accused of having committed, then he could be disarmed. In other words, we should rely more on the criminal law than on these restraining orders, which are civil orders. So he's at least saying that he would consider, or seems to be signaling that he would consider such a prohibition constitutional. But again, if this case doesn't rise to that level, where we have a person who has committed domestic abuse, who a judge has individually found presents a credible threat to another person, if even that person can't be disarmed constitutionally, it is a little harder for me to see what kind of fact pattern would satisfy him.
I mean, the fact pattern here was particularly egregious. He not only assaulted his girlfriend and threatened to shoot her, but he threatened a different woman with a gun. He opened fire in public 5 times and shot an AR-15 rifle into a home. So not a good fact pattern to bring to the Supreme Court if you're the gun lobby, let's say.
Yeah, I think this case, unlike, for example, District of Columbia versus Heller, which is sort of the first major modern Second Amendment case, which really was one where there was thought put into who do we want the challengers to be. This case came up because Zaki Rahimi's public defenders did exactly what they should do, which is, when Bruin came down, raise an argument that the law he was being prosecuted under was unconstitutional. It's exactly what defense attorneys should do. But it didn't come through the pipeline in the way that, maybe a sort of institutionally guided test case might. In that respect, certainly bad facts for those who might want a different champion for gun rights. Although, looking back on it, I think most gun rights organizations, maybe all of them, filed in support of Rahimi for different reasons, not all of them saying you can't disarm domestic abusers. There were concerns about potentially due process and other issues. It's not that people distance themselves necessarily, but I think most people certainly wouldn't celebrate him as the face of the gun rights movement.
Thanks so much for being on the show, Joseph. That's Professor Joseph Blocher of Duke Law School. A note: Michael Bloomberg, the founder and majority owner of Bloomberg LP, the parent company of Bloomberg Radio, is a donor to groups that support gun control, including Everytown for Gun Safety. Coming up next, the Supreme Court gives the State Department unfettered authority over granting visas. I'm June Grasso, and you're listening to Bloomberg. On Tuesday, President Joe Biden announced an executive action to streamline the process through which undocumented spouses of U.S. citizens apply for lawful permanent residence.
For those wives or husbands and their children who have lived in America for a decade or more but are undocumented, this action will allow them to file the paperwork for legal status in the United States, allow them to work while they remain with their families in the United States.
At the same time, his administration was taking a position in the Supreme Court, making it impossible to challenge the denials of visas for spouses of American citizens, even if it means the couple can't live together in the U.S. And on Friday, in a 6-3 decision down ideological lines, the Supreme Court agreed with the Biden administration and said the constitutional rights of U.S. citizens are not violated when the government bars their non-citizen spouses from entering the country without explanation. Joining me is Leon Fresco, a partner at Holland Knight and the former head of the Justice Department's Office of Immigration Litigation in the Obama administration. Leon, tell us about this married couple. They've been separated since 2015. She's been living in the U.S. and he's been living in El Salvador.
The wife is a U.S. citizen, and she marries her husband, who's a citizen of El Salvador. And so what the wife tried to do was to file what's called a marriage immigrant visa petition, which says that if you marry someone, if you're a U.S. citizen, you can bring your foreign citizen spouse into the United States through a process by which, in step 1, you show that the marriage is legitimate, and in step 2, there's an interview. Now, if you're in the U.S., that interview is in the U.S., but if you're outside of the U.S., that interview is at a U.S. embassy. And so this interview takes place at the U.S. Embassy in San Salvador, El Salvador, and at that interview, they actually deny this person's visa, which is pretty rare in the case of a green card. It's very common that people's visas get denied when it's visitor visas or tourist visas or other kind of visas that are short-term. But for a marriage green card visa, usually those get approved unless there's some problem. And here, this one actually gets denied with a very weird category, which is not that they actually say that the person did something wrong, but it's this kind of nebulous category that's in the statute, which makes this case a little bit more tragic because it says that the consular officer believes, here's the actual quote, knows or has reasonable ground to believe that the alien seeks to enter the United States to engage in offenses that are unlawful activity. So this is sort of a prediction. It's not really based on anything. So the U.S. citizen wife asked, well, why do you think this? What prediction are you making? And they got someone in the State Department who knew somebody, whatever, to say that the reason this got denied was because her husband has gang activity in their background. And then the wife said, but my husband doesn't have gang activity. And they said, well, why does he have these tattoos or whatever else? And so the wife tried to convince the State Department that tattoos were not gang tattoos. This is a common source of litigation in other cases. But in the end, they don't get anywhere, and they sue the State Department saying that they have a constitutional right to be able to challenge this decision.
And Leon, this decision was really broad and encompassed more than it had to.
The court decision is actually quite expansive, much more than anybody could have expected. So for the past 40 years, in these cases of visa denial, there has always been the court assuming without deciding, hey, you don't really have any rights with regard to visa denials, except that if a visa denial affects a U.S. citizen, we're going to assume but not decide that that visa denial can withstand any court challenge if it has a facially legitimate and bona fide reason, meaning that at the bare minimum, you couldn't just deny the visa by saying it's Taco Tuesday and all visas get denied on Taco Tuesday. No, you have to actually cite a legal provision that was in the actual code and say this was the reason. Now, that doesn't mean that that reason had to be correct, but you at least had to pick a reason in the code. But what's fascinating about this case is the court says we're done with this assume without deciding thing, and we're saying that nobody, not even the spouse of a U.S. citizen, has the right to challenge a visa denial, and there's nothing special about a spouse of a U.S. citizen, so end of story. So now, if a visa is denied even conceivably for Taco Tuesday, nobody can go into court and challenge that and say, hey, Taco Tuesday isn't one of the legal reasons you can deny a visa. No. Now nobody can go to court for any reason to challenge a visa denial.
So does this decision then stand for the proposition that a citizen doesn't have a fundamental liberty interest in a non-citizen spouse being admitted to the country?
So the law prior to this Munoz case starts with the only right that anybody has is to a facially legitimate and bona fide reason for denial. And so Munoz says, well, I need to do something better than that or else I'm going to lose my case because I already have a facially legitimate and bona fide reason, which is that they think that my husband was in a gang. So I'm not going to win with that. So she goes into court and argues that she has more rights than a normal visa applicant who's only entitled to this facially legitimate and bona fide reason, and that her rights come from the fact that she has some extra substantive due process right to a better explanation for why her husband was denied that she can then have a procedural due process right to challenge. And so what the Supreme Court says is, look, you don't have either a substantive or a procedural due process right because in either of those two analyses, it requires that the right actually have some historical root to it or grounding to it. And the right to live in America with your spouse has never been one that's been recognized in the history of America. Yes, the right to marriage has been, but not the right to live in America with your spouse. And especially because immigration law has always traditionally given deference to the executive branch and how it administers immigration, it runs contrary to logic that there would be this right constitutionally that's been in our history to live in America with your spouse. But because they go there, they then say that even in this scenario, where you're married to a U.S. citizen, you're entitled to nothing. So now everybody's entitled to nothing. You're not even entitled to a facially legitimate and bona fide reason. We're ending all of this assuming without deciding stuff And guess what? Now nobody can go into court ever and challenge a visa denial for any reason in court.
And this is a court that usually tries to resolve disputes on narrow grounds.
Correct. And that's why Justice Gorsuch concurred in the judgment but didn't join. He said, I don't cast aspersions on my colleagues who may see this case differently than me, but I don't think we needed to do any of this. And so he concurs in the judgment, which is quite frankly, if I was on the Supreme Court, what I would have done is just say, look, this is like every other case. You need a facially legitimate and bona fide reason and nothing else. But the court really breaks new ground here and basically says the State Department now has 100% control over who gets in and who gets out. And 99% of that time, it's going to be one consular officer. And by the way, I would say 99% of the consular officers are very hardworking people who devote their lives to do very selfless things like work at a consular window in Nigeria or in Afghanistan or somewhere else. So, I mean, their lives are not so easy. But nevertheless, they have maybe 2 minutes or 3 minutes in an interview with these individuals, and they're making lifelong judgments that are now completely unreviewable. And so all I would say there is with great power comes great responsibility. And you would hope that those decisions are going to be exercised very carefully moving forward, since there is no solution if they're wrong.
And Leon, in her dissent, Justice Sonia Sotomayor warned that the ruling is an obvious sign the court is going to seek to overturn protections for marriage equality next. Tell us about her fears.
So she's worried not so much about my concern in the immigration code head world about the consular officer now having 100% freedom to deny for any reason, even Taco Tuesday. Yes, they're concerned about that and now are worried that this attack was done for the purpose of saying that not only does marriage play no role in the immigration context, marriage is playing too much of a role in other contexts in the law. Hence, now things like the Upheld decision, which was the decision that granted the right to have same-sex marriage, could be under threat now, because now the idea is if you don't have rights in and of yourself that you can claim to marry another person, that could be then used to eradicate that right, that substantive due process right to quote unquote reside with the rights of relatives and get married. And so that she views this as a very obvious first step toward the unwinding of the Obergefell decision that made same-sex marriage a constitutional right.
Coincidentally, this week, President Biden announced an executive order to protect undocumented spouses of U.S. citizens. Explain that for us.
Yes, ironically enough, those two things happened in the same week. What the president did is say, I, as the president and as this administration, view this issue of being married to a U.S. citizen to be so unique that if the person is here, as opposed to the Supreme Court case where the person is abroad, if the person is here and the reason they cannot stay with their spouse is because they entered illegally, because people who come legally and overstay their visa can already have their problems fixed by marrying a U.S. citizen, but you cannot have your problems fixed by marrying a U.S. citizen if you entered in the first place illegally. He said, I will fix this problem by pretending essentially that everybody entered legally. And the way I will do that is by giving them a permission to be treated as if they entered legally by giving them a document called parole in place. So you will be able to apply for this parole in place that, let's say, as of August 1st, 2024, will mark the day you entered, quote-unquote, legally under this new parole in place. And because you, quote-unquote, entered legally with this new parole in place, then you will be able to apply for a green card on the basis of your marriage to a U.S. citizen, which you were not able to do prior to this announcement because you had not entered legally. So that's what the announcement changes, is the Biden administration is allowing people to come forward to do this with the limitation that they had to have been in the country for 10 years and that their marriage had to have been validly legal prior to the announcement.
So Biden's executive order and this Supreme Court decision are two separate things.
They're absolutely two separate things. and one doesn't rectify the other. And in fact, one becomes a little bit more necessary because of the other in this sense, which is prior to the Biden announcement, if you entered illegally, then you actually have to leave the country and get what's called a waiver to re-enter. That's what the current system is. You have to get permission from a consular officer. And so what is interesting about this decision is now if the consular officer wanted to say, we don't give waivers on Taco Tuesday, now there would be no way to attack that, even though that's completely illegal. You used to have to give a reason. Now you cannot go into court, even if they were to say something as egregious as that. And so that would even make people more terrified to have used the legal pathway, which is why the Biden administration could argue that they need this new pathway that doesn't require people to leave, because people will not take that risk of leaving and being subject to not being able to come back in if a decision was against them for some arbitrary reason. Now, having said that, I will note that the Biden administration asked for the ruling that the Supreme Court issued today. They represented the State Department. They asked for that ruling. The State Department has never wanted any check on its ability to issue visas from the courts. It's always wanted the courts completely out of this, and now it finally got its wish. And this has been a priority regardless of party, and the Biden administration didn't put any limitations on the State Department's arguments. So they are just as responsible as any other administration for saying that the State Department should have unfettered authority to make their visa decisions.
So then the courts won't have to deal with these anymore. Thanks so much, Leon. That's Leon Fresco of Holland Knight. Coming up next, court upholds a tax on foreign income. I'm June Grasso, and this is Bloomberg. Whereas former President Donald Trump says he would extend and expand his 2017 tax cuts, President Biden says he wants to reform the tax code so that wealthier Americans and corporations pay more. And he doesn't miss an opportunity to slam the Trump tax cuts.
At the same time, he and his mega allies in Congress were happy to give the very super rich a $2 trillion tax cut in his administration. $2 trillion.
A tax case before the Supreme Court was being closely watched because of its potential implications for proposals to impose a wealth tax. But the court skipped that question, at least for now. In a 7-2 vote, the justices upheld a Trump-era tax on American-owned businesses' foreign profits, rejecting an appeal that might have required the IRS to refund hundreds of billions of dollars in taxes companies have already paid, and could have upended other parts of the tax code. Joining me is leading tax scholar David Schizer, a professor at Columbia Law School. This hasn't been one of the most closely watched cases of the term. Just how important is this decision?
This decision is very important for what it says and also for what it doesn't say. What it says is that many of the international tax provisions that the U.S. government has used to tax income from foreign corporations are constitutional, and that's a very important holding. And at the same time, what it doesn't say is whether something like President Biden's mark-to-market income tax is okay. They haven't told us whether Congress can tax people on appreciated stock when they haven't sold the stock.
Tell us about the facts of this case.
So the Moores are U.S. citizens who bought stock in an Indian company. They have not sold the stock. They have not received a dividend. And so ordinarily, under U.S. law, you don't pay tax until you sell or until you get a dividend. Here, they received a tax bill based on what the foreign company was earning. And this was part of a major U.S. reform effort for corporate tax in 2017. So the Moores said, hey, wait a minute, you can't tax us because we haven't sold and we haven't gotten a dividend. And the court said, actually, you can be taxed. And initially, the court thought they were taking the question of can someone be taxed without a sale, but it's actually not the issue that the case presented. And the reason is that the corporation, the Indian company, was realizing income. And so the court said, well, as long as the company had these sales and was realizing income, Congress could attribute those sales to you. And so basically, this became a case about the relationship between an owner and the corporation instead of a case about whether you could tax an owner without a sale.
Was it an unusual lineup of justices, the 7-2, Thomas and Gorsuch in dissent?
What you have is a division of views about things Congress could do. There is a 7-2 majority for the idea that Congress can treat an owner as the entity for purposes of taxing the owner. You can say, hey, owner, we're going to treat you as earning the income of your entity. And there are 5 justices that say that can be done pretty easily. And there are 2 that say we think it can be done, but only when there's an abusive situation. And then 2 who say they don't think it can be done. But on this other question of, can you tax someone for appreciation when they haven't sold? There you have 4 justices who've come out saying the answer to that is no, it would be unconstitutional. You have 5 that say we don't reach that question. One of those 5, Justice Jackson, wrote a concurrence saying, in effect, she'd be fine with it. But as to the other 4, we don't yet know where they are, and that'll be for another case.
So Paul Ryan, the former House Speaker who helped write the legislation, said upending the tax could endanger 1/3 of the U.S. tax code. Do you agree with that number?
The broadest holding here could have cost trillions of dollars to the Treasury. So I do agree. Really, the way the court came out, blesses most of what Congress is already doing. What Congress has not tried to do, but the president proposed it a few months ago, is to say, hey, you founded this company, your stake is now worth $1 billion, and we're going to tax that income on your stock, the fact that it's gone from 0 to $1 billion, we're going to tax you under the income tax, even though you haven't sold. And Congress has not done much of that. And as for what it's done, there's still a question whether it can. And if it decides to do that, that's still an open question about whether the court would bless it.
Did Justice Kavanaugh, who wrote the majority, did he specifically say we're not ruling on any other hypothetical taxes? We're just resolving the issue before us today?
Yes, he did. And he also made another point. There's another kind of tax, which is, hey, you're rich, and it's not that we're going to tax your gains. We're just going to tax your net worth. That would be a wealth tax. That's the tax that Bernie Sanders and Elizabeth Warren have proposed. And interestingly, Justice Kavanaugh said, we're not deciding that. But he also added there that the government, during oral argument, had conceded that a wealth tax would be unconstitutional. So I think he didn't just note it. I think he sent a signal that he thinks, like the government, that that would be unconstitutional.
And did the government really concede that a wealth tax would be unconstitutional in the oral arguments?
Yes, they did. There's this idea in the Constitution of a so-called direct tax, and a direct tax is subject to a very unappealing requirement called apportionment, which basically means that the amount of revenue collected from a state has to be the same as its percentage of the population. And if you had to apportion a wealth tax, Bernie Sanders and Elizabeth Warren would have no interest in it, because the net effect of that is that the wealth tax rate would be higher in poorer states. So when asked in oral argument, does the constitutional amendment for income taxes cover a wealth tax, or would a wealth tax be a direct tax? The representative for the U.S. government said that would be a direct tax. So the government did concede that a wealth tax would be unconstitutional unless it was apportioned.
So were the plaintiffs here looking for something more from the court, something about those hypothetical taxes we've been discussing?
Because of the conversation in the country about wealth taxes or about an income tax that doesn't wait for you to sell, and because Congress has been considering those steps, I think the taxpayers brought this case in an effort to give the court the chance to say that those new rules would be unconstitutional. As it turns out, they did not pick their vehicle wisely. They did not pick the right case, because this case really presents a different issue. It's much more about whether you can tax an owner for what the business is doing instead of the business. And that's the narrow basis in which the court resolved the issue.
So who are the real winners here?
I think it's a win for Congress and the Internal Revenue Service, in the sense that a very important long-standing body of rules that are designed to protect U.S. tax base against efforts to move income overseas, I think those rules were blessed as authorized. But on the other hand, there's still a big open question, and in a sense, a mini-win for opponents of these other tax reforms, because the court certainly did not bless them, and we have 4/9 of the court explicitly coming out against them, and heavy hinting from the majority that it would be a different analysis and no one should assume that they're constitutional.
I know you wrote an amicus brief in this case. Tell us about your position in the brief.
We actually said we thought the issue that the court said it was taking wasn't presented, and that instead this was a case not about whether realization is constitutionally required, but about whether an owner could be taxed for what its business is doing. And our theory is exactly the theory that the court adopted.
Well, it's quite something to have the Supreme Court adopt your position. And this decision means that $271 billion in taxes remains in the Treasury.
Yes, so the government doesn't have to give that back. But the stakes were much broader because this was a case about whether, on a one-time basis, Congress could tax earnings in overseas companies. So the one-time basis was approved, but the reasoning the court gave in approving it was this is just like a different rule where there's other overseas income that we've been taxing all the time. And we think that's constitutional as well.
Finally, one more thing about the wealth tax. What are the long-term implications of the government conceding in the oral arguments that a wealth tax would be unconstitutional?
The government can change its position in a future case. So the fact that the government made that concession is not binding. But I think the fact that the court chose to memorialize the concession is a signal of what the current court thinks about the issue.
Thanks so much for joining me, David, and helping to unravel the complications of tax law. That's Professor David Schizer of Columbia Law School. The Supreme Court is down to the finish line with 14 cases left to decide before the term ends, and usually that's the last week of June. But almost all of those cases involve controversial issues, including Donald Trump's claims of presidential immunity, Idaho's near-total ban on abortion, the regulation of social media, fines for homelessness, air pollution rules, the opioid crisis, and the power of federal agencies. Will the justices issue a flurry of blockbuster opinions next week, or will they extend the term into July, something that happened last at the height of the pandemic? Joining me is constitutional law scholar Harold Krent, a professor at the Chicago-Kent College of Law. Hal, even if in these controversial cases there are multiple dissents and concurrences, should it take this long with 14 cases left for the last week?
It shouldn't take this long. There may be a strategy, I'm afraid, of releasing many controversial decisions at once. So it sort of like mutes the overall reaction because nobody knows where to start. And so the presidential immunity case, the sleeping in the parks case, Grants Pass, and of course all of the very incendiary administrative law decisions that have yet to be released. You just release them all together and nobody knows where to start because they're all so important and also controversial. That may be a strategy, or it's perhaps, a justice or two can't finish a key concurrence or dissent, and that's what's holding up the court.
And is it the Chief Justice who decides when the opinions come out?
Chief Justice does decide that, but the question is, will he give a deadline to a fellow justice that an opinion's going out, whether or not the concurrence is ready? That's not generally the case, but obviously the court doesn't want to stay past July 4th. The court may even want to finish by the end of June. So it's getting close where the Chief Justice may say, if it's not in by a certain day, we're releasing the opinion the way it is. That's the leverage that the Chief can hold over the fellow justices.
Well, Wednesday is the next day that's announced for opinions, so we'll see what happens then. Thanks, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.